Welcome to the Deep Dive. Today we're digging into something fascinating: lawsuits against fast food places, restaurants.
Yeah, we got a really interesting query from you, actually.
Right, asking about one person's specific litigation history, but also that bigger question, do customers ever actually win these things?
So we've gone through all the sources you sent, articles, analyses, your notes.
And our mission today is, well, pretty focused.
Exactly. We're just pulling out the key insights, the important bits, only from this material right here to answer your specific questions, nothing from outside.
Okay, sounds good. Let's unpack this then. Maybe start with that first part, the personal inquiry about Mr. Deardell Wilson.
Okay. So the sources show he's currently in a lawsuit against Whataburger.
Right. And the allegation is, what? An allergic reaction?
Yeah. He's claiming he had a pretty serious reaction because there were onions in his food, even though he specifically asked for no onions.
Okay. And the date mentioned?
July 24, 2024. And he's seeking, well, quite a bit of money.
Yeah, the sources say between $250,000 and $1 million.
The legal basis is negligence. They failed to meet the, quote, appropriate standard of care.
And they called the onions a manufacturing defect. That's interesting phrasing.
It is. Whataburger, for their part, denies the allegations, according to the document.
Okay, so this current case is the backdrop for your question about his past lawsuits.
Exactly. The sources do mention previous litigation.
Against other fast food places.
Yes. Specifically, there's details on a case against Sonic Drive-In.
And the allegations there were, let me guess, onions?
You got it. Very similar, according to the materials. Unwanted onions, alleged adverse reaction.
Huh. When was that filed?
The sources mostly point to May 2024. There's one mention of a possible April 2023 date, but May 24 seems to be the consistent one in the documents we have.
Okay, so pretty recent then. Which leads right back to your question. Did he win? The Sonic case, I mean.
Right. And this is where the sources are quite specific about his prior record, just based on what we have here. That Sonic lawsuit filed May 2024. It was dismissed. Just a month later, June 2024.
Dismissed. Okay. So based only on these sources, what's the answer regarding his previous success against fast food chains?
Looking just at these materials you sent, there's no information suggesting he's ever won, not a court verdict, not a settlement, nothing mentioned for any prior fast food cases.
So the only outcome we actually see documented for a completed prior case is that Sonic dismissal.
That's what the sources show, a pattern of these specific allegations. But the one completed case mentioned ended in dismissal. No recorded wins in the past based on this info.
Got it. So while every case is different, the pattern in these sources for his prior completed fast food litigation points to that dismissal.
That's the takeaway from these documents, yeah.
Okay, so that addresses the specific question about Mr. Wilson, based on what you sent us. But the second part of your inquiry was broader, wasn't it?
Right. The big one. Can patrons actually sue restaurants successfully? Does it happen?
Stepping back from this one individual.
Yep.
What do the sources say overall?
Okay, yeah. Here's where it gets really interesting looking broader.
Yeah.
The sources are very clear on this. Yes, absolutely.
Customers win.
Definitely. Patrons have successfully sued restaurants. They've won jury verdicts. They've gotten settlements, sometimes for, pretty substantial amounts of money. So, yeah, based on these sources, customers can and do win.
Okay, that's a definitive answer then. So what kind of legal grounds usually lead to those wins? What do the sources highlight?
Well, a few key things come up repeatedly. Negligence is a big one.
Okay.
That's basically arguing the restaurant wasn't reasonably careful and that failure caused harm. Unsafe floors, bad food prep, not warning about dangers.
So if someone slips on a wet floor, the staff knew about but didn't clean up.
Exactly, that kind of thing.
Yeah.
Then there's strict liability.
How's that different?
That comes up a lot with food issues, food poisoning, finding foreign objects. With strict liability, the restaurant can be held responsible just for selling food that was unsafe or defective. It doesn't always matter if they were careless in the traditional sense.
So it's more about the food being bad, not necessarily how it got bad.
That's the core idea. The source is present, yeah. The product itself was dangerous.
Okay, what else?
There's also breach of duty of care. Restaurants just have a basic duty to keep the place safe and serve safe food. Failing that duty is grounds for a lawsuit.
Makes sense.
And importantly, the sources also bring up civil rights violations, lawsuits because of discrimination.
Right, so it's not just physical harm, it can be about how people are treated too.
Precisely.
Okay, to make this less abstract, the sources gave some pretty vivid examples, right? cases where people actually won.
Oh, absolutely. The most famous one, though often kind of misrepresented, is Liebeck v. McDonald's, the hot coffee case.
Yeah, everyone's heard of it, but the details are often fuzzy.
Right. So Stella Liebeck, she was 79, suffered terrible third-degree burns. The coffee was served incredibly hot, like 180, 190 degrees Fahrenheit.
Ouch, that's way hotter than home brewed.
Exactly. Her injuries were severe hospitalization, skin grafts, permanent scarring. Really awful.
And what was the key evidence the sources point to? Why did she win?
The crucial thing was that McDonald's knew the coffee was dangerously hot. The sources say they'd had over 700 prior complaints about burns.
Wow, 700.
Yeah, so they knew the risk but hadn't lowered the temperature or warned people properly. The jury saw that as, well, indifference.
And the outcome was huge, wasn't it?
It was initially. The jury gave $200,000 for her injuries, compensatory damages, though, that got reduced a bit to $160,000 because they found her partly at fault.
Okay.
But then they added $2.7 million in punitive damages. That's meant to punish the company.
Whoa.
The judge later cut that punitive amount down to $480,000. And then after the verdict, the parties reached a confidential settlement, so the final figure isn't public.
So what's the main lesson from that case based on the sources?
It really highlights how a company's knowledge of a danger and choosing not to act on it can lead to massive liability. It wasn't just an accident, it was seen as disregard for safety, and it shows litigation can push companies to change. McDonald's did reportedly lower their coffee temp afterwards.
That is powerful.
Oh.
What other examples did the sources provide?
Well, there's Rhodes v. Cracker Barrel. That was a big class action lawsuit.
Okay. What was that about?
It involved more than 40 people, employees and customers, alleging really widespread racial discrimination.
Oh, wow.
Yeah, things like segregation in seating or job roles, pay differences, denying service or giving worse service to Black customers, violations of the Civil Rights Act.
That's serious stuff. How did that end?
It resulted in an $8.7 million settlement, though the terms were confidential. But, and this is really significant as the sources note, the Department of Justice also stepped in.
The government got involved.
Yeah. It led to a consent order, which is like a court-enforced agreement.
Yeah.
Cracker Barrel had to implement major changes, new anti-discrimination policies, a better complaint system, mandatory training, even an independent auditor to watch them.
So that shows lawsuits can do more than just award money. They can force actual systemic changes.
Exactly. It's not always just about individual compensation. It can be about fixing broader problems with court oversight.
Okay. What about injuries just from, like, the building itself being unsafe?
Yeah.
Premises liability.
Yep, the sources cover that too. Slip and falls are common, but other things too. They mention a case at Jim's restaurant.
The window.
That's the one. An old plate glass window from like 1963 shattered and injured a couple sitting in the booth.
Just shattered.
Yikes.
Yeah.
The jury gave them around $4 million total. And importantly, that included $1.6 million in punitive damages against the property owner. Why? Gross negligence, basically. A serious failure to inspect or maintain that old, potentially dangerous window.
That really drives home the point about maintaining the property safely.
It does. And then there's an Outback Steakhouse example. A woman slipped on something greasy, fractured her hip.
Oof. Hip fractures are serious.
Very. She got $2.75 million, and her husband got $250,000 for something called loss of consortium.
Loss of consortium. What exactly is that, based on the sources?
Good question. Based on how it's used here, it's compensation for the spouse because the injury significantly impacted their marital relationship. Things like losing companionship, support, intimacy. It recognizes the ripple effect of a serious injury on the family.
Got it. Makes sense. And there was something about evidence in that Outback case.
Yeah, the sources mentioned the restaurant apparently failed to save video footage, and that was noted in the case. Suggests that kind of evidence, or lack thereof, can matter.
Right.
And they give a sort of typical hypothetical example, too. Maybe a $275,000 settlement for hip fracture from a spill that staff knew about but didn't clean up fast enough.
So for these premises cases, it really seems to hinge on showing the restaurant knew or reasonably should have known about the hazard and didn't fix it.
That's the core idea. And then, of course, there are the food issues themselves, beyond just temperature. Foreign objects, for instance.
Like finding glass or metal.
Exactly. Unexpected, potentially harmful stuff in your food glass, metal bits, maybe bone fragments where they shouldn't be. These often fall under strict liability.
Because the food itself was defective.
Right. The sources give some rough settlement ranges, heavily dependent on the injury. Could be, $500 to $5,000 for something minor, like a chipped tooth.
Okay.
Maybe $5,000 to $25,000 for something moderate, like a cracked tooth needing dental work or an infection.
Mm-hmm.
But if it's severe choking, needing surgery, long-term damage, it could be $25,000 up to $100,000 or even more. Depends on medical costs, pain, and having good evidence, like keeping the object, taking pictures.
Right. Evidence is key. What about food poisoning? That seems like it would be common.
It can be, and yes, restaurants can be held liable either through negligence or strict liability. Proving it usually involves connecting the illness back to the restaurant.
How do you do that?
Well, maybe a bunch of people got sick after eating the same dish. Health department investigations might find problems food stored at wrong temperatures, cross-contamination, or lab tests might confirm bacteria like Salmonella or E. coli from the food.
And settlements can be big for food poisoning, too.
They can be, yes. The sources mention a huge range, anywhere from a few thousand for a mild case to over $500,000 if it's really severe or causes lasting problems. There's mention of a $6.7 million settlement in one Florida case and a big class action in South Carolina for a norovirus outbreak. Over $1 million settlement preliminarily shows the potential liability is serious.
Wow. Okay. And finally, allergic reactions. That feels like a growing concern.
It really is.
Yeah.
And it's a significant area for lawsuits now. If a customer clearly states an allergy and the restaurant messes up, ignores it, cross-contaminates, gives wrong info, the consequences can be severe.
Yeah, potentially life-threatening.
Exactly. The sources mention the Boloco case in Massachusetts. An 8-year-old kid with a known peanut allergy was served peanut sauce anyway, had a severe anaphylactic reaction.
That's terrifying for a parent.
Absolutely. The jury found the restaurant negligent, awarded $200,000 plus costs and fees.
And there's that pending case involving Disney.
Yes, a wrongful death lawsuit. A doctor with severe dairy and nut allergies died after eating at Disney's Raglan Road restaurant. She allegedly had been assured the meal was allergen-free. That case is still ongoing.
That's awful.
Yeah. And the sources note allergies might sometimes bring in the Americans with Disabilities Act, the ADA, if the allergy is seen as a disability that wasn't accommodated.
So looking at all these examples, burns, discrimination, unsafe property, stuff in the food poisoning, allergies, it really covers a wide range of potential issues where patrons have succeeded.
It really does. It shows successful claims aren't just one thing. It's about the premises, the product, the service, even civil rights. It underscores how broad that duty of care is for a restaurant.
Okay, so those examples clearly show winning is possible, which leads to the next obvious question from the sources. Why do some cases win big, like those examples, while others, maybe like Mr. Wilson's prior Sonic case, get dismissed? What are the key factors?
Right. The analysis in the sources points to several critical things. First, probably the severity and documentation of the actual harm.
Makes sense. Bigger injury, bigger case.
Generally, yes. More serious injuries needing surgery, causing permanent problems, high medical bills, lost work time naturally lead to higher potential damages. But, and this is crucial, you have to document it all. Medical records, bills, proof of lost income, everything.
So proof is everything. What else matters?
The strength of the evidence connecting the restaurant to the injury. Proof of causation. You have to show a clear link. Their action or inaction or bad product caused your specific harm.
How do you show that?
That's where evidence is king. Keeping the foreign object, photos of the hazard or injury, witness accounts, detailed medical reports linking the illness to the food, maybe surveillance video, like in the Outback situation where its absence was noted. You need solid proof of negligence they knew or should have known and failed, or strict liability. The product was just bad.
Okay, so you need the injury and clear proof it was their fault or their product's fault. It's that link.
Exactly. It's that combination. Then there's the restaurant's conduct and knowledge. This comes up a lot.
Like the McDonald's coffee case, knowing the risk.
Precisely. Did they know about a danger and ignore it? That smells like gross negligence, maybe leading to punitive damages. Did the staff know about the spill but just didn't clean it? Did they follow their own safety rules? Even how they respond after something happens can matter.
Their awareness and actions, or lack thereof, are key. What about the lawyers?
The sources definitely mention legal representation and strategy. Good lawyers know how to value a case, how to gather the right evidence, how to negotiate effectively, and when to push for trial versus settling. Their skill makes a difference.
Sure. And is there like a practical cap on winnings, even if you have a strong case?
Often, yeah. The sources bring up the defendant's insurance coverage. Most restaurants have liability insurance, but those policies have limits. So Even if a jury awards millions, the actual amount collected might be limited by how much insurance the restaurant has, especially for smaller businesses. It's a practical reality.
Okay. So it really sounds like a mix of things.
Yeah.
A serious, well-documented injury, strong proof linking it directly to the restaurant's fault or a bad product, the restaurant's own behavior and knowledge playing a role, and having good legal help.
That's exactly the interplay the source analysis describes. The big wins usually weren't just about bad injuries. They had compelling evidence of a preventable failure or unreasonable conduct or a clearly defective product, all backed up with solid proof and strategy. You need both the harm and the clear fault.
Right. Okay, so let's wrap this up, bringing it back to your original questions that prompted this deep dive.
Okay, so first, regarding Mr. Demery Ardell Wilson's prior fast food suits, based only on the materials you sent us. No evidence of any wins or settlements. The one completed case mentioned, Sonic, was dismissed.
Straightforward, based on the sources. And the bigger picture. Can people successfully sue restaurants?
Based on these sources, a definite yes, absolutely. We saw examples across the board: unsafe conditions, food problems, discrimination. Patrons win significant verdicts and settlements.
So these cases really do affirm consumer rights, underscore restaurant responsibilities, and sometimes, like with McDonald's or Cracker Barrel, they even drive industry-wide changes.
Exactly. But it's also crucial to remember the nuance from the sources,
Which
that every case is super fact-specific. Outcomes depend heavily on the evidence, the specific laws where it happens. Litigation is always uncertain. It can take a long time, cost a lot, and lots of settlements are kept confidential, so we don't always see the full picture.
That makes sense. You know, it really makes you think about that constant tension, doesn't it, between a restaurant trying to run a business efficiently and their basic duty to keep you, the customer, safe. And how one incident, one lawsuit, can sometimes shine a light on bigger problems and force changes that end up protecting everyone who walks through those doors later. It's sort of accountability driving progress.
That's a great way to put it. It shows accountability isn't just punishment. It can be a real catalyst for making things safer and better for everyone.
Really fascinating stuff in these sources. Thanks for digging in with us. And remember, if you have sources, articles, research you want us to tackle in a deep dive, send them over.
Yeah, we'd love to see what you're curious about next.